สู่การแข่งขันแถลงการปิดคดีด้วยวาจารอบชิงชนะเลิศ CIPIT Court Young Ambassador Award 2017 ในปีนี้นะครับเสร็จสิ้นไปแล้วสำหรับการแข่งขันของทีมภาษาไทยและในคู่ต่อไปนะครับจะเป็นการแข่งขันทีมภาษาอังกฤษนะครับจะเป็นการพบกันระหว่างทีม Law Light Love นะครับรับบทเป็นฝ่ายผู้ร้องนะครับพบกับทีมผู้มี่นะครับรับบทบาทเป็นฝ่ายผู้คัดค้านนะครับขอเสียงปรบมือให้ทั้งสองทีมด้วยครับครับและท่านคณะกรรมการทั้ง6ท่านที่ขึ้นตัดสินในรอบภาษาอังกฤษนะครับประกอบด้วยท่านปรัชญาโกษัยการนนท์นะครับอธิบดีผู้พิพากษาศาลทรัพย์สินทางปัญญาและการค้าระหว่างประเทศกลางท่านธรรมนูญพิทยาพรรองอธิบดีผู้พิพากษาศาลทรัพย์สินทางปัญญาและการค้าระหว่างประเทศกลางท่านวิชัยอริยนันทกะผู้พิพากษาอาวุโสในศาลทรัพย์สินทางปัญญาและการค้าระหว่างประเทศกลางท่านธนกรอินทพันธ์ผู้พิพากษาหัวหน้าคณะในศาลทรัพย์สินทางปัญญาและการค้าระหว่างประเทศกลางท่านกฤษภกาบุญเฟื่องและท่านอัศวินเตชะเจริญวิกุลผู้พิพากษาสมทบในศาลทรัพย์สินทางปัญญาและการค้าระหว่างประเทศกลางครับและขณะนี้ท่านคณะกรรมการพร้อมด้วยผู้เข้าแข่งขันทั้ง2ทีมนั้นพร้อมอยู่แล้วนะครับขออนุญาตเริ่มทำการแข่งขันการแถลงการปิดคดีด้วยวาจารอบชิงชนะเลิศทีมภาษาอังกฤษณบัดนี้ครับ
Good afternoon. Welcome to the second session of the oral argument, closing oral argument in the International Trade Court, Central Intellectual Property and International Trade Court of Salakhan. The facts in this case are quite simple. The fact arises out of the alleged breach of bilateral investment treaty which entered into between Federal Republic of Myanmar and the Kingdom of Salakhan. This BIT gives the local standard or standing to bring a dispute to arbitration under the uncial arbitration rules. The BIT treaty enables an investor from one contracting state investing in another contracting state if and when there's a breach of this protection of investment agreement to bring the dispute to arbitration. And in this case, Tobacco Inc., which is a legal entity under the law of the Federal Republic of Myanmar, who registered its trademark tobacco Kool, K-O-O-L, Kool, in Salakhan, and accordingly the trademark was granted, and hence tobacco has the exclusive right on the trademark Kool in Salakhan. Since this is a well-known mark, and then it is also protected under the bilateral investment treaty between the two countries. The situation is this. Salakhan happened to have a public health minister who is very keen on organizing or on protecting the public health from cigarettes and tobacco. So a new regime, a very strict regime on tobacco, including the advertisement of cigarettes and even the package used for the cigarettes must contain 80% of the space for graphic, very graphic pictures that chosen by the Public Health Ministry depicting the disadvantages or the effects of tobacco and cigarettes, and only 20% is used to have the trademark in the plain language. So tobacco feel that this is a breach of its exclusive intellectual property right, and it is the breach under the bilateral investment treaty. And after a lengthy negotiation with Gamma, the negotiation failed and failed. So finally, Tobacco Incorporated brings an action against Salakan to the arbitration tribunal in Geneva, Switzerland. And finally, the award from the tribunal granted Tobacco the amount of 10 billion baht in damages for Salakan's breach of BIT against Tobacco Inc. plus 100 million baht for expenses and attorney fees. The Kingdom of Salakan failed to pay the damages, so Tobacco Incorporated seeks enforcement of the award in our court. So today we are hearing the closing argument from counsels on both sides. We have counsels from the Kremlin on this side and the counsel of respondent from here. So we have both parties argue for both sides in the time allocated. So we will hear from the first attorney of the claimant, please.
Your Honors and May it please the Court, we are a Law Like Love team, and today we represent the claimant Tobacco Inc. So I was asked the first question that the legal measure for anti-smoking promulgated by Salakan in violations of exclusive right, and my co-counsel was asked another questions. So Your Honors, trademark is an intellectual property that created from the commercial way. The origins of the trademark is different from the author's intellectual property, and trademark is unlimited of renewal. So that means the trademark is protected as long as the owners want. And the thing that we have to consider that the functions of the trademark, we have four elements. The first is origins of the functions, and the second is quality guarantee that is proposed to guarantee its quality. And the third, the advising function is advised about the product and show this is a product from this trademark. And fourth is create an image. So let's talk about in the fact. Some countries no need to register the trademark, but almost countries we depend on the register system. Why? We have to show that we have the right to use this trademark, and someone might concerning that why we have to register, because we have to protect our right. So, and if we look in the business way, we have to have the right in the trademark, because we have a lot of budget to do in this product. So that's why we have to protect our trademark. So the main reason that we have to have the legis system, because like we have to protect the monopoly that gonna happen a lot in the future. That's why. So in the facts, tobacco registers the coal as a trademark KOL, but policy of Salakhan, cool, yes. But Salakhan lets our company to change the trademark to like the trademark to the word mark, just like the cool. So and they didn't tell the reason that makes sense for our company. So the element that's important to register the trademark. So the first is detective, and another is like not against the law, and the last one is not similar with the author. So I have example for product, right? So I don't know why Salakhan raised me to like change my trademark. So they have to say to our like just like, oh, you have to accept the public's policy, but they don't accept. They just like let our change to the trademark to word mark. But it's a good example to like to run the business. Why they don't let like something like that? Just like, oh, just trademark, your trademark, you're right. Why you have to change like that? That's I want to say. So and they just use the law like legal measure, not include the intellectual property law. Just use another legal to against our right. For example, like our register to like trademark office, right? But they just like left public health to against our law. So that's why it is appropriate to against our right. That's point. And the second point that I want to explain, Your Honor, according to Constitution's Section 4 and Section 34, that we have freedom of advertisement. Why you have to like why you have to don't let me like advertisement our product. So you give the point that we have to like make a plain packaging. This point is affect a lot of things. So I have to give example like if you let me to make it plain packing. So the person that for example the person that can like cannot read alphabetically or something. So or maybe like buy another cigarette that discount or low cost more than our company. So I mean like to let the people to buy the fake product. It is very affect to the society that the Salakhan cannot control or not. If you let our to like be turned to plain packaging, that's why. And another thing that I want to say that in psychological purpose, if you let me have like 80% on the product that show about like the thing that everyone wants to see, right? So I think that it not affects new smoker that much because someone is smoke cigarette. It have a lot of something that motivates. For example, stateful or the bad environment. So it doesn't mean that we have to change our trademark. So and another reason that I want to tell is public policy. Public policy. Why don't you use the measure of that's gonna affect a lot. Why do you still like let our chain trademark? That's our right. So I don't know why. Is it appropriate to against our right in this point? Yes, and I think the good to solve this this point because like the tag it affect a lot of everyone, so that's why you don't use this point. So, and the last one that I want to say is the cigarettes that show in our packaging. Is too much? Is it like it's against our like too much because in Europe or Scotland they show like 60% of public health and 40% of trademark. Why you still let me like not show our trademark? So this is my point. So all my reason that I want to tell. Thank you.
So presumably you like the second council to continue.
Yes.
Please.
Thank you.
By the way, would you like to keep that away? We wouldn't want to put True Corporation into any legal trouble, would we? Because this is a live broadcast, right?
Your Honor, and may it please the court, I would, as I represent the claimant, and I would address the third question, which is, can the court refuse the enforcement of the arbitral award on ground of contrary to the public policy? First, we need to know about what is an arbitration. An arbitration is an ADR, or an alternative dispute resolution. It benefits a lot in the commercial dimension. First, it's a quick process, so both parties don't have to suffer for a long period of the legal process in which will damage their business, or their business might be falling out. The next one is it's confidential. It is kept as a secret. Some information in the business might not be appropriate to get exposed. So in the arbitration, it solves that problem. And the third one is trust. Both parties can agree to choose the arbitrator that they trust. That arbitrator will be impartial and will be fair towards both of them. And the most important part is that the arbitration is in a friendly manner. Both parties don't have to end with winner or loser, or winner, loser, yeah. It don't have to fix in that. It can benefit both of us. So the business that we might be doing together will not be falling off. As they have many strengths in the arbitration system, that's why it is accepted and honored in many countries. So, as in the fact that the arbitration system is an agreement, Sarkhan country agrees willingly to be a part of the arbitration system, which is in the arbitration clause in the BIT, or bilateral investment treaties, stated an arbitration clause, which is therefore an arbitration agreement. As it shows that the respondent knew the strength of the arbitration, that's why the respondent chose to be in the process of arbitration. Then why did the respondent refuse to act according to the arbitration reward? You first agree to be a part of the agreement. your act is kind of between your acts, it becomes inconsistent. It's against each other. First, you agree to be in the arbitration process, and then when the result came out, you didn't act according to the arbitration award. Your act also infringed the New York Convention, which imposed the precedence of the arbitration system, which is imposed by the UNCITRAL, by the UN. This showed that the arbitration is accepted and honored even by the UN. And this kind of inconsistent act of the respondent show bad faith. First, they agree, and then they don't do as they agree. And if you refer that it would be a public policy, the contrary to public policy should be interpreted very carefully and in a very limits. If otherwise, it would result in the it would be not good towards the overall arbitration system. If this one came out okay, and this one is not as according to the arbitration award, how can the investors be sure that their arbitration system will be all right, will be enforced? And as a result, is unpleasant to the respondent side. And if you say it's for the public interest, for the public policy, to persuade the court so that the court will refuse to enforce the arbitration award, I would say there is a precedent, the use of public law, the public health law is a kind of public law in which there are a precedent that there is a principle of proportion. To use the measure, it should damage the private sector at the minimum. The act of the respondents are not respect to the principle of proportion, which is have to benefit for the public the most and to create the least benefit towards the private sectors. For example, the revolt in the land. The state have to get the land to build the public transportation, but they have to revoke just the minimum amount, or it will cause too much damage in an unnecessary way. And they also give a measure to cure the damage arising upon those acts by giving them the money. So, for the Respondent Act, don't you have any other measures which will benefit the public health and not damaging the private sectors? As my late counsel also already said, that the reducing size of the tobacco, it would result in just a very small word mark. Therefore, many kinds of trademark will be similar. The design would be in the plain letters. Therefore, many people will think, oh, this one is the same, and they lose their reputation. The reputation they try to create, which used a lot of time. Just first, the registration process. It used at least 6 months in Sarakan to be able to register a trademark. And the Sarakan, the tobacco, are a well-known mark as it is famous and everyone recognized in 150 countries and have the market share of 60% in Sarakan. And if the trademark becomes a word mark, wouldn't it be confusing for the consumers? And it would be easier for other company to forge, to try to make the similar kind of name mark, the word mark. And it would create a mess. It would the illegal cigarette might be take part, and wouldn't it be a lot more harmful? Would it be a lot worse than for the lawful cigarette? And as I said, is it the last resort, or is it just a measure without paying attention to the economic and the society? The IP protection is a very important part for the business sectors, as it is according to the commercial business, we have to protect the rights of the trademark and many stuff. Therefore, if the law, which is to protect for the commercial benefits, lose its trust, if they don't give the protection to the IP or intellectual property law, the investors would lose their trust towards Sarakan country. Wouldn't it be worse for Sarakan country in the overall? And if the court decide to not enforcing the arbitral award, how would it be for the arbitration system? How the investor might see the arbitral award is also an important part in the business sectors. If both the IP law and the arbitration system are destroyed, everyone will lose their trust. How can the investors be sure to invest in Sarakan? It would result in a butterfly effect. And right now, there's a PWL, or the priority watch list, which is very, very harmful, which if we lose the trust, we will be in a priority watch list as Thailand. We wouldn't want Sarakan to be the same as Thailand. That's why we wouldn't want, I beg the court, I request to enforce the arbitration for the sake of the arbitration system, for the sake of the intellectual property law, and for the sake of justice. Therefore, I submit my submission.
Thank you, both counsels, for the comment. Now, let's hear from the counsels for the respondent.
Mr. President, Your Honors, may it please the Court. I will be pleading on behalf of the respondent, the Kingdom of Sarakan. I will be the first to address the issue of the respondent's alleged violation of the claimant's rights in its trademark. My co-counsel will then address the issue of the respondent's alleged violation of the constitutional rights and the enforcement of the arbitral award. Your Honors, the tobacco epidemic is a global problem with serious consequences for public health, killing 6 million smokers and 890,000 secondhand smokers each year, according to the World Health Organization's fact sheet in 2017. Your Honors, the danger caused by cigarettes and tobacco have been witnessed firsthand by the government of Sarakan, which has been compelled to allocate a huge amount of its annual budget to alleviate the public health concerns resulting from their consumption. Your Honors, Sarakan as a state thus has the duty to serve public interests in promoting good health by eliminating or limiting the danger caused by cigarettes and tobacco. Your Honors, this is a duty it owes to the people of Sarakan by virtue of public policy for the welfare of the people, as reflected in Section 71 of the Sarakan Constitution, which encourages the promotion, development, and enhancement of health. Your Honors, the Sarikhan government has chosen to do so by imposing 4 anti-smoking measures, including first, the prohibition on advertisements of tobacco and cigarettes. Second, the prohibition of the public displays of trademarks for tobaccos and cigarette. And third, the requirement that 80% of the cigarette packaging must be devoted to depicting graphic images of the illness caused by smoking. And fourth, the requirement that 20% of the package can be used to display the trademark in plain language. Your Honors, these anti-smoking measures were implemented with the intention to deter and discourage smoking by first, providing knowledge as to the health effects and the health risks which are associated with smoking, and second, eliminating the creation of misleading impressions which serve to downplay the severity of such risks and glamorize or encourage smoking. Your Honors, these measures are in line with Sarikhan's international obligations and have been the subject of much acclaim and recognition within the international community. Your Honors, the claimants have requested that the court enforce an arbitral award compelling the respondent to pay 10 billion baht in damages to the claimants. Enforcement of such an award, Your Honors, would be implying that to act contrary to the measures imposed by the respondent would be lawful. Your Honors, the enforcement of such an award would completely disregard the public policy of the promotion and protection of public health. Your Honors, the issues in dispute in the present case is whether, first, these measures are in violation of the exclusive rights on the trademark cool conferred by the respondent to the claimant. Second, whether these measures are in violation of the constitutional rights in the Sarikhan Constitution. And third, whether the court can refuse to enforce the arbitral award. Your Honors, with regard to the first claim, the claimants have elaborated upon the functions of the trademark, the reasons for registration of the trademark, and the elements for registration. However, Your Honors, the claimants have failed to establish a legal basis for the right it claims to exist. Your Honors, we submit that the anti-smoking measures imposed by the respondent are not in violation of the exclusive right of the claimants to its trademark. Your Honors, Section 44 of the Trademark Act provides that a person who is registered as the owner of a trademark shall have the exclusive right to use such trademark for the goods and services for which it is registered. Your Honors, the exclusive right referred to in Section 44 is a negative right, which is used to prevent others from using the same or identical trademark in goods and services. It is not a positive right, which will confer upon the trademark registrant the right to use the trademark in commerce. Your Honors, this would mean that the state has a duty to facilitate the use of the trademark for the claimants, which is not the case. This is so regardless of the fact that the claimant claims that its trademark is a well-known mark. Your Honors, we submit that this interpretation is correct because it is in line with, first, the Trademark Act, and second, the international conventions to which Sarikhan is a party. Your Honors, considering the first, the Trademark Act provides that the trademark registrant is entitled to the following rights. First, the right to bring legal proceedings to prevent or to recover damages for the infringement of a trademark. Second, the right to petition the board for the cancellation of an identical or similar trademark. And third, the right to bring legal proceedings against criminal cases of unauthorized use of the trademark. Hence, it is apparent from the Sarikhan trademark law that the Sarikhan trademark law recognizes a right to prevent others from using the trademark and not a right to use the trademark in commerce, as has been suggested by the claimants. Your Honors, The claimant has failed to indicate any provision in the Trademark Act which provides a remedy for the violation of a right to use the trademark as it claims exists. Therefore, it cannot claim that such right exists. Your Honors, considering next the international conventions to which Sarakan is a party, Your Honors, Article 16 of the TRIPS Agreement is titled Rights Conferred and lists the rights conferred upon the trademark owner upon the registration of such trademark. Your Honors, in particular, Article 16.1 of the TRIPS Agreement provides that the owner of a registered trademark shall have the exclusive right to prevent all other persons from using the trademark without the owner's consent. Your Honors, if the negotiators of the TRIPS Agreement had intended for the trademark owners to have a positive right upon the registration of its mark, then they would have explicitly said so. Your Honors, furthermore, Article 8 of the TRIPS Agreement provides explicitly that members may, in formulating or amending their laws and regulations, adopt measures necessary to protect public health. This notion is further reaffirmed by the declaration of the TRIPS Agreement on Public Health, which provides that the TRIPS Agreement does not and should not prevent members from taking measures to protect public health. Your Honors, similar regulations with regard to the packaging of the tobacco products may be found in over 100 nations, some of which impose more drastic regulations than those imposed by the respondent. For example, in Nepal and Australia, both of which are parties to the TRIPS Agreement, 90% of the cigarette packaging is required to be devoted to health warnings. Your Honors, it cannot be said that all of such nations are in violation of their rights under international conventions. Your Honors, there must be a reasonable expectation of regulations such that no absolute right on trademarks may be conferred. Your Honors, the rights of a trademark owner are granted to them by the state. Thus, the state has the right to similarly limit such rights in specific circumstances. The mere fact of registering a trademark does not mean that the sale of all products which have the trademark are allowed in all circumstances without other considerations. Your Honors, if there are no further questions, that concludes my submission.
So the second counsel, please.
Mr. President, Your Honors, may it please the Court, I'll be pleading on the behalf of the respondent, Kingdom of Sarakan. I'll be speaking on the respondent alleged violations of constitutional rights and the enforcement of the arbitral award. The first issue I'll be addressing is the issue with regard to the violation of the constitutional rights. First, the claimant counsel has submitted that there's a violation of freedom of expression of the claimant. However, Your Honors, there's no violation in freedom of expression by the anti-smoking law. Section 34 of the Constitution does recognize the freedom of expression, which includes the right to advertise the product of the claimant. However, Your Honors, under the same provisions, there is an exception provided that by the virtue of the provision of law specifically enacted in order for the purpose of the protecting of the people's health in the countries, those liberties may be limited. However, the restriction imposed by the law must be in accordance with Section 26 of the Constitution, that is, it must be proportionate and shall not be intended to apply to any particular case or persons. Your Honor, as earlier submitted by my co-counsels, that the anti-smoking law is intended to protect and promote public health of the people in Sarakan by restricting those rights of the tobacco company. Therefore, in order to see whether the rights is constitutional or not, we must first the law must first pass the proportionality test. In order to pass the proportionality test, there are 4 elements to be considered. First is the legitimate goal. Second, the suitabilities. Third, the necessities. And fourth, the appropriateness. First measure, Your Honors. The goal of the restrictions must pursue the legitimate goal. Legitimate goal in this sense means that the goal of the law must be in accordance with the constitutional value. Under Section 71 of the Constitution, it states that the government has a duty to promote public health of the people in the countries, and the anti-smoking law is passed in order to promote and protect the health of the people in Sarkhan. Therefore, the purpose of the law is in accordance with the value recognized by the constitutions, and therefore it has a legitimate goal. The first element, therefore, is fulfilled. The second, moving on to the second element, the suitabilities. The measures must be suitable. That is, it must at least help the government achieve the goal. There are 4 measures introduced by this anti-smoking law. First, the prohibition on the advertisement of the cigarettes and tobacco. Your Honors, WHO fact sheets thus provided that the comprehensive ban on the tobacco advertising, promotions, and sponsorship that help decrease the tobacco consumption rate by average of 7%, and even in some countries it's experiencing a decline in consumption of 16%. This proves that the first measure does help the government achieving the goal. The second measure is the prohibition on the displaying of the trademark for cigarettes and tobacco in public. Your Honors, marks and the products are connected. When the people see the mark, they would immediately think of the product. For example, even the consumer only see the mark Coca-Cola individually without the products. They would immediately think of the black color soft drink. Therefore, if the display of the trademark is still allowed, this will render the first measure ineffective, as people will still see the mark and think of the tobacco, and they would want to smoke anyway. Therefore, the second measure is also help the government to achieve the goal. The third measure is the requirement that 80% of the cigarette package have to have the picture of the illness causing from the smoking on the package. Your Honors, those pictures will inform the smoker that smoking is harmful. And WHO fact sheets also provided that the package warning, especially those which contains the picture, can help reduce the amount of the teenager who going to start to smoke and can increase the number of smokers who quits. This also proves that the third measure is work and help the government achieving the goal. The fourth measure is the requirement that 20% of the remaining package can be used to display trademark in plain language. Your Honors, color, font, and how the mark is designed can suggest or give a signal to the consumer that certain type of brand is less harmful than the others or is of better qualities than the others. Therefore, by displaying trademark in plain language, people will not be falsely misled by the design of the mark into believing that certain type of cigarettes is less harmful than the others. This shows that these standardization requirements thus reduce the attractiveness of the package in order to diminish the consumptions. After all, anti-smoking law can actually help the government achieving the goal of public health, because people will be informed that smoking is bad and eventually will quit smoking. Therefore, the second element, which is the suitabilities, is fulfilled. Moving on to the third element, Your Honors, it is the necessities, which means that the restrictions must be necessary. There must be no less severe measure of the same abilities. Other measures that the government may impose in order to achieve the same goal, that is to make people in Sarkhan stop smoking, is that the government can even put a total ban in the sale of the cigarettes. However, those measures are too severe, and even deprive the right to operate the business of the tobacco company even further. Therefore, this proves that the measure introduced by the anti-smoking law is the least severe measure that could achieve this goal, because it does not totally deprive the right of the tobacco companies to operate a business, and also the right of the smoker to smoke, because this measure is merely a choice-preserving measure. The smoker still have a choice. It's only influence their behavior. It does not totally prohibit the consumers. The Claimant Council has submitted that there are less severe measures that could be done by the government, namely the tax measure. However, Your Honor, those tax that put the huge burden to the consumers, and it shows, and there's an evidence that this measure does not as effectively as the measure imposed by the anti-smoking law, because nowadays the government also imposed a very high number of tax on the tobacco. Each package is cost like 100 baht, which is really expensive. However, the people still smoke because some of them does not have the knowledge, that does not be aware that of the damage that might cause from the smoking. Therefore, this proves that the tax measure proposed by the Claimant Council is not a less severe measure that could achieve the same purpose of the law. Therefore, this measure proposed by the anti-smoking law is the least severe measure that could produce this outcome, and therefore third element is fulfilled as it is necessary. Moving on to the last element, Your Honors, it is an appropriateness. This measure must be appropriate in the sense that the benefit of the measure must outweigh the burden inflicted by the actions. We must weigh between abstract significance and the concrete gain and impact of this case. Your Honor, the abstract value in this case are the public health and the freedom of expression. However, the real life impact on this case is that the company will not be able to fully exercise the freedom of expression. However, they still be able to put their name, to put their mark in the plain language on the package. However, what the society got from this measure is that there will be less smoker and less second-hand smoker, and overall, people in the country will be more healthier and have a better life. When comparing the impact and gain, the gain is more significant because it's just not because the company, the claimant, still has the right, still can exercise its freedom of expression to a certain extent. However, without the policies, people will actually die and suffer from the sickness such as cancer or emphysema, or which known in Thai as Thung Lom Pong Pong, because of this tobacco epidemic, which may lead to other problems in the society as well. For example, the negative effect on the workforce. As a result, the law does not unreasonably impose burden to a party, and there is a justification and necessities for the restriction imposed by the law. Therefore, the measure introduced by the law is proportionate. And moreover, there is no discrimination in this law, as the law is applied to both foreign investor and the local investor equally. Therefore, the law is not intended to be applied to any particular case or person, and it is proportionate. As a result, this public policy is a public policy that is constitutional and is justified as a public policy of Sarkhan, Your Honors. Next issue I'll be addressing is the issue with regard to the enforcement of an arbitral award. Your Honor, an arbitral award should not be enforced on the ground of contrary to public policies. Section 44 of the Arbitration Act specified that the court may dismiss the application of the enforcement of an arbitral award if such enforcement is contrary to the public policies. Your Honor, public policies within the meaning of Section 44 should be defined as the internal public policies. This interpretation is consistent with Article 5(2)(b) of the New York Convention, to which Sarkhan is a party and from which Section 44 is derived from, which state that the recognition and enforcement of the arbitration awards may be dismissed if the recognition and enforcement of such arbitral award is contrary to public policy of that country. Your Honors, the public policy of Sarkhan at stake in this present case is the protection and promotion of the public health. Such internal policy is consistent with international concern on the adverse effect of tobacco consumption reflected in first, the World Health Organization Framework Convention on Tobacco Control, to which Sarkhan, together with 168 countries, are signatories to. And the second is the Declaration on TRIPS Agreements and Public Health. Your Honors, as previously submitted, the measure restricting the use of the trademark were implemented to further advance these public policies. Therefore, such award which order the respondent to pay 10 billion baht for damage to the claimant for the implementation of the anti-smoking law may inaccurately suggest that the act of the claimant is lawful under Sarkhan law, which aim to eliminate and limit the danger caused by the cigarettes and tobacco, in accordance with Sarkhan public policies on protection and promotion of public health. Your Honor, such an award is therefore contrary to public policy, and Sarkhan is entitled to refuse the enforcement of such arbitral award under Section 44 of the Arbitration Act. If there is no further questions, this concludes our submissions.
Right, thank
May
you.
it please the court.
Tobacco Incorporated, you have a final rebuttal for closing statement. You have 10 minutes. If you'd like to use it now, please.
Your Honor, I may please the court. I will be starting my closing statement. As my learned friend stated that the illness showed in the tobacco, which is to providing knowledge that smoking would cause these kinds of illness, the WHO has recommended just 50% is enough to provide that kind of knowledge. And because if it is for 80%, the trademark will be very, very small. And furthermore, it becomes just word mark. It can create more confusing towards the customers. And it would be easier for forge, as I said before. And as a result, it might be the illegal cigarettes might come to the market, and it would cause more harmful health towards the smokers. And as the procedures to use not to provide this one, if the smoker already smoked it, they wouldn't be scared to this one. They will still be smoking. It just prevents the newcomers, new smokers, to smoke. And as she said that the tax is putting burden to the consumers, this act of hers would be a burden to the producers of the cigarettes. And it would be a burden to the economic dimension. And if, as I said before, if the illegal cigarettes come, would it be a burden to the consumers as well? And it would destroy the registration system, as the tobacco registered for the trademark, but he just got a word mark. Even its name shows that it's not a trademark. So it's we didn't got what we registered for. And as it limits the right too much, because it is against the principle of proportion, the tax, and there's the Doha Declaration on Public Health that the public health and the IP, intellectual property, can be together, can put an end that benefits both, not benefits just the public health, but harm the intellectual property, harm to the economic dimension, and there will be no investors want to invest in Sarakan. The economic dimension would be in a crisis. And as the respondent are willing in the BIT or bilateral investment treaties, she is willing to be a part, willingly to be in the agreement. And this shows that if the favor is the result of the arbitration favors the respondent, she would agree to the award. But as it is not in her favor, she starts to not honor the awards and refuse to do as the act. It shows that she is not sincere to the arbitration system, which will damage if the unsincerely acts of hers becomes contrary to the law. It would not be a benefit for the arbitral system, the intellectual property system as well. And that act is also an infringement to the FET, which means transparency, non-discrimination. She said that it's not a discrimination because she do it to every kinds of cigarettes. But what about the kind of other harmful products, such as the beers or alcohol? There's a big trademark and just a small sentence saying it would be harmful to health. Very small, but this one is 80% with the picture of the illness. Is that fair? Is that a non-discrimination act? And the third one is good faith. As I said before, she just tried to be a part, willing to be the part. Sarakan wants to be the part of the arbitration system, but she agreed to be the part. But the favor, when the favor is not in for her in her sake, she just not agree to the result. It's just like she's shopping for the case, shopping for the result of the case, and it would not be appropriate for the enforcement of the awards. Your Honor, the arbitration benefits both parties concerned. It is honored all over the world in many countries as the best tool to solve the disputes in a friendly manner, in a peaceful way, so that their relations still remain, not destroyed by winner or loser. For the sake of the arbitration system and for the sake of intellectual property, for the sake of the economic dimension, as the spirit of law wanted it to be, as there are a lot of measures that can benefit both the public health and both the economic dimension. Therefore, I conclude my submission.
Counsel for the respondents, you have 10 minutes.
Mr. President, Your Honors, I would like to make the following remarks to what the claimant has claimed. Your Honors, the claimant has claimed that 50% of the packaging is enough to provide knowledge. However, we submit that 50% cannot be as effective as the 80% requirement imposed by the respondent because, Your Honors, a bigger picture will of course create a greater impression as to the harmful effects of cigarettes and therefore will be more effective in deterring and discouraging consumers from smoking cigarettes, which will be in line with the public policy of Sarah-Can. Your Honors, next, the claimants have submitted that tax would be a better alternative than the anti-smoking regulations imposed by the respondent. However, as already submitted by my co-counsel, tax will impose an unnecessary burden on the consumers, and it is not as an effective remedy as the measures imposed by the respondent, as stated by my co-counsel and as supported by the statistics quoted from the World Health Organization. Your Honors, third, the claimants have raised the Doha Declaration in support of its claims. However, Your Honors, the Doha Declaration itself provides that the TRIPS agreement does not and should not prevent members from taking measures to protect public health. Therefore, the Doha Declaration is consistent with the actions of the respondents in the present case. Your Honors, fourthly, the claimants have alleged that the respondents have acted in bad faith and have not respected the bilateral investment treaty to which it is a party. However, Your Honors, the fact that the respondent has entered into a bilateral investment treaty does not mean that the respondent is obligated to enforce all awards rendered by the arbitral tribunal by virtue of such bilateral investment treaty. The respondent has acted consistent with its obligations under the New York Convention and under Article 44 of the Arbitration Act in using the exception of public policy to refuse to enforce the arbitral award. Your Honors, lastly, I would like to comment on the claimant's assertions that the respondent has discriminated in its treatment of products, as the respondent has not imposed similar measures with beer, or in other words, alcohol. Your Honors, in order to create discriminatory treatment, the government must have either first, treated the same factual case differently, or second, treated the different factual cases in the same manner. Your Honors, the respondent has committed either of these acts of discrimination. Your Honors, beer and tobacco are two completely different products and are completely different in nature, as alcohol is not always harmful when consumed. Alcohol may have positive effects as indicated by medical research if consumed in an appropriate amount. Your Honors, when consumed in an appropriate amount, alcohol may have positive effects for the cardiovascular system.
Are you trying to promote alcohol now?
No, Your Honors, I'm merely indicating that there is a difference between the products. Your Honors, on the contrary, tobacco is the only legal consumer product which kills when used exactly as intended by the manufacturers. Therefore, these two products cannot be compared, and therefore the respondent has not acted in a discriminatory manner by not imposing the same requirements on the sale of alcohol. Your Honors, to conclude, the respondent would like to emphasize that if the court were to enforce this arbitral award, it would effectively be invalidating the anti-smoking measures imposed by the respondent and undermining the public health concerns which underlie these measures. Your Honors, if there are no further questions, that concludes my submission.
Thank you, counsel for both sides. So that's the first part. You showed your research and your argument on the prepared topics or issues. But now, You have to show your ability to defend whatever questions that put to you. So this is the perhaps the most important skill of a practitioner, that is to be able to defend whatever you argue for. So I will start with the counsels for the respondent, if I may. Now, the counsel for the claimant raised a very good proposition that you, Salakan, as a state, has entered into a treaty with Gamma to protect the investment from nationals from Gamma. But it doesn't exclude the investment on tobacco and cigarettes. If you, as a country, as your policy for public health, feel so strongly about tobacco, why don't you put it in the BIT that this treaty does not include tobacco industry in the first place? Is that a fair assumption? What would you like to say to that? You can consult and then you don't have to marry.
Your Honors, if I may.
Yes, of course.
Your Honors, in drafting the bilateral investment treaty, Sarakan cannot be expected to have anticipated all events which may become of value to the state in the future. Therefore, to answer your first question, why has Sarakan not included the concern of public health and tobacco in its bilateral investment treaty? This is because it cannot have anticipated that this will become a concern.
If Sarakan could have anticipated the effect from tobacco and cigarettes, would Sarakan exclude tobacco from the investment?
Yes, Your Honors, we would. Your Honors, I would further like to note that as the bilateral investment treaty has already been concluded, afterwards, in the present case, the bilateral investment treaty must be interpreted in light of the public policies of Sarakan and the public policies which are internationally recognized, which is the public policy of the protection and promotion of public health. This is consistent with, for example, as invoked by my co-counsel, the Framework Convention for the Tobacco Regulations by the World Health Organization, and the Doha Declaration, as also invoked by the claimants.
Is that a question put to the court?
No, Your Honors.
So another point that you have raised is interesting too. You say that it's all right if Sarakan does not discriminate based on the country of origin, because the measure for tobacco also apply to domestic produced tobacco. Is that right? But it is not discrimination if the goods of not similar kind but other kind, but also affects the public health, like alcohol. We must accept for a fact that alcohol also affects the public health. So it is not discrimination if the Sarakan doesn't do as serious measure, doesn't create as the serious measure as it does with tobacco, and that's not discrimination. Is that your contention? Yes? So what do you think? You raised that it is discrimination because you treat tobacco in the different way as you treat alcohol. So you claim that this is discrimination,
Yes.
and it's not fair, and it's offend the BIT, fair and equitable. So would you like to argue on that point?
Yes, Your Honor.
And of course, you will have response after that.
As for my learned friends already stated that it is fair. I'm not agreeing to that because both alcohol, she's saying that the state is saying that the nature of the tobacco is causing health. But the alcohol also create a crisis because it makes people lose their consciousness. And there are a lot of incidents in the news, as you can find almost every day, about the rape, about the killing, which most of them, or even the accident from the car accident, some of them are from the unconsciousness from drinking alcohol. And there are a lot of more incidents that is not caused by the tobacco, such as the killing, violating other people, harming them, like some kind of have a fighting, which much worse. If you want to protect the public health, why not protect in every way, every measure? Why just the tobacco? Why just the cigarettes?
I see your point, but her definition of discrimination is that to treat different thing the same or treat the same thing differently. Do you agree with that definition?
I think it should be treated almost the same way, so that would not create any discrimination. Because alcohol also have a lot of disadvantages that might cause incident. But just the logo is still in there, and a very small caution say below.
All right, we have some time for Q&A, so would you like to respond to that?
Your Honors, the claimant's example of drinking and driving as one of its support for its claim is not reasonable, and it's not comparable to the present case, because road accidents do not occur as a direct consequence of drinking. There must be the intervening event of driving in order to create road accidents. Therefore, road accidents are not the direct consequence of alcohol, and you cannot compare these two circumstances together. Your Honors, furthermore, we have already implemented other measures which are more suitable to address the specific issue of alcohol, such as the ban on its sale in certain times of the day or in certain days of the year. And we submit that this is an effective measure for alcohol, which is different in nature from tobacco and cigarette products.
Good. Another question. One of your proposals is that your proposition is that intellectual property rights is a negative right, not a positive right. And you say that, well, the right of a trademark owner is to prevent others from using it without authorization. So I hear you correctly or not. You could tell me, this isn't a right to be used in commerce, something like that?
I said that it was not a right to, it's not an exclusive right that
it is an exclusive right. It is.
It is an exclusive right,
Yes.
but it is not an absolute right that the trademark owner will always be able to use its trademark in commerce.
Used in commerce. So what about commerce? What about trademark licensing? Is it used in commerce?
Yes.
So it's positive, right?
Yes. What I mean to say is that the trademark owner can use the trademark as it wishes when there are no regulations imposed upon the state. So it can license the trademark or do anything with its trademark as long as this does not violate other rights.
That's right. So it can advertise the trademark too.
Yes, Your Honors, as long as there is no other regulation prohibiting it from doing so, which has been promulgated by the state.
Good. And would both sides, since we have too much time now, can anybody help us in balancing the interests of the public right on the one hand, maybe called public health on the one hand, and intellectual property right, or maybe the contractual right that this state contract to protect the investment, and then you have an investor investing on activities that you welcome, tobacco industry, and then you have these measures. How would you address the balancing of interest on that? Maybe you ask us not to enforce the award, so the burden is on you. Is it correct? Good.
Your Honors, we submit that our anti-smoking measures achieves an appropriate balance between, on the one hand, private rights conferred by virtue of trademark registration and the public policy of promotion and protection of health. This is because, first, we do not completely deprive the claimants of their use of the trademark. The trademark can still be used, only in a limited space. And so that is why it achieves an appropriate balance.
Would you like to say something before we have a recess?
As the fact shows that the Sarkhan country is obliged by the BIT, and there's also an arbitration clause, which means the Sarkhan country agrees to have the arbitration system if there are disputes occur during the investment. And the BIT means that both countries agree to help promoting the investments. If there are the measures of the limiting anti-smoking, why not stating in the BIT in the first place, not damaging the exclusive right? And if to say that the exclusive right is not an absolute right, the proportion of the proportionality principle stated that it should be benefits a lot, the most, and have the least damage to the private sectors. But as for this one, and there's only 20%, and people can see, can recognize, and it will be a lot more crisis that might happen. And just the word mark, the Sarkhan country stated that it would prevent from people might be interested in the trademark, but it wouldn't affect the smokers, the current smokers. It only prevent the new smokers. And if she said that the tax is not the best way, is a burden to the consumers, so isn't this the more burden to the consumers? If there's a fraud and illegal, as I said before, illegal cigarettes, it would be more harmful. There would be a lot more percentage of nicotine in the cigarettes and a lot more harmful substances. Would it be more, and we can't control the cigarettes anymore. Right now we can control the cigarettes. And if that happened, if we can't control the cigarettes, would it not be a lot more harmful to the society? And as the respondent have been to the arbitration, and the Sarkhan country didn't act according to the awards, it shows that the Sarkhan country is not sincere towards the agreement, towards the BIT agreement, and both the arbitration system, and it means that the Sarkhan law fails to award the owners of the trademark. It would affect a lot crisis in terms of economic dimension. There are a lot more measures that could be found to benefit both public health dimension and both the economic dimension. Is this the last resort, the last way to prevent, to help the public, to help the public health? And as for the sake of economic dimension, please, I
This is breathing from here.
therefore I submit my conclusion.
Thank you. So we'll adjourn and we'll come back with a very unfortunate part, the result.
ครับก็ได้เสร็จสิ้นลงมาแล้วครับสำหรับการแข่งขันแถลงการเป็นคดีด้วยอาจารย์ในทีมภาษาอังกฤษนะครับช่วงเวลาจากนี้ประมาณ15นาทีนะครับท่านคณะกรรมการจะใช้เวลาในการรวบรวมผลคะแนนการแข่งขันครับแล้วเดี๋ยวกลับมาพบกับการประกาศผลนะครับครับขอนำทุกท่านเข้าสู่การแข่งขันแถลงการปิดคดีด้วยวาจารอบชิงชนะเลิศนะครับภายใต้โครงการทูตเยาวชนศาลทรัพย์สินทางปัญญาและการค้าระหว่างประเทศกลาง CIPIT Court Young Ambassador Award 2017 ซึ่งช่วงเวลาที่ทุกคนรอคอยได้มาถึงแล้วนะครับช่วงเวลานี้ท่านคณะกรรมการได้รวบรวมผลการแข่งขันของทั้งทีมภาษาไทยและทีมภาษาอังกฤษเสร็จเรียบร้อยแล้วโดยท่านคณะกรรมการจะได้ขึ้นประกาศผลทีมผู้ชนะภาษาไทยก่อนและในช่วงเวลาต่อเนื่องกันจะได้ขึ้นประกาศผลทีมผู้ชนะภาษาอังกฤษพร้อมกันเลยนะครับและขณะนี้ท่านคณะกรรมการได้พร้อมแล้วขอเรียนเชิญท่านคณะกรรมการทีมภาษาไทยครับ
ถึงเวลาที่ความจริงเราไม่ค่อยมีความสุขเท่าไหร่ที่ต้องทำหน้าที่ในการประกาศนะครับแต่ว่าก็จำเป็นนะครับ
ในเรื่องของการก่อนประกาศว่าผู้ใดจะเป็นผู้ที่ได้คะแนนแล้วก็เข้าเป็นผู้ชนะหรือเป็นผู้ชนะเลิศในการแข่งขันก็เราก็แข่งขันกันมาหลายนัดแล้วก็ตามธรรมเนียมก็ต้องให้คอมเมนต์กับแต่ละฝ่ายเพื่อประโยชน์ในการศึกษาเพิ่มพูนความรู้ต่อนะคะว่าข้อบกพร่องของแต่ละท่านหรือว่าจุดดีของแต่ละฝ่ายเป็นอย่างไรซึ่งก็คอมเมนต์ในเรื่องของผู้ร้องก่อนนะคะให้ความเห็นของผู้ร้องไม่เป็นไรค่ะเชิญนั่งก่อนนะก็พูดโดยภาพรวมนะคะว่าทั้งสองฝ่ายก็เยี่ยมมากในการนำเสนอต้องจัดว่าการว่าความนั้นเป็นศิลปะแขนงหนึ่งนอกเหนือจากวิชาความรู้ที่เราควรต้องศึกษาประกอบไปด้วยการว่าความนั้นต้องมีวิธีการจูงใจและทำการบ้านมาอย่างดีนะคะในการนำเสนอเพื่อให้เรื่องราวที่นำเสนอนั้นน่าสนใจและก็เข้าใจตามนะคะในฝ่ายของผู้ร้องเองเนี่ยก็เห็นว่ามีการนำเสนอที่ถึงมาตรการในการที่จะกีดกันทางการค้าของทางฝ่ายผู้คัดค้านคือประเทศสารขันซึ่งโดยเนื้อความแล้วเนี่ยก็เห็นว่าตรงประเด็นกับโจทย์ที่มีอยู่ว่าประเด็นปัญหาของเราคือจุดของเราคือเรื่องการค้าเสรีซึ่งเราต้องให้น้ำหนักว่ามาตรการต่างๆที่รัฐกำหนดมานั้นเป็นการกีดกันทางการค้าเสรีอย่างไรซึ่งเราประสงค์ให้นักศึกษาเนี่ยได้เข้าใจบริบททฤษฎีว่าเบื้องหลังของการต่อสู้มักจะมีหลักการกฎหมายอยู่เบื้องหลังนะคะว่ามาตรการในการบังคับใช้เพื่อไม่ให้สินค้ามีการแพร่หลายในจำนวนที่รวดเร็วหรือกระทบต่อ ผลประโยชน์ของรัฐเป็นอย่างไรบ้างซึ่งก็มีทั้งผลประโยชน์ของรัฐในแง่ของความสงบเรียบร้อยศีลธรรมอันดีรวมถึงสุขภาพอนามัยซึ่งในประเด็นนี้เนี่ยน่าจะเป็นจุดที่ฝ่ายผู้คัดค้านต้องเน้นหนักว่ารัฐมีความจำเป็นต้องออกกฎหมายเพื่อประโยชน์สาธารณะอย่างไรบ้างซึ่งจะเป็นจุดที่เรียกว่านิวยอร์กคอนเวนชั่นหรือกฎหมายพระราชบัญญัติอนุญาโตตุลาการเองได้กำหนดไว้ในมาตรา 44 ว่าเราจะไม่รับบังคับคำวินิจฉัยของอนุญาโตต่างประเทศได้เนี่ยในกรณีที่มันขัดต่อผลประโยชน์ของรัฐซึ่งเราต้องนำเสนอในจุดนั้นนะคะให้เน้นหนักส่วนฝ่ายนี้ต้องนำเสนอจุดที่ได้เปรียบอยู่แล้วคือมีคำวินิจฉัยของอนุญาโตในเรื่องให้ประโยชน์เพราะถ้าอนุญาโตตุลาการซึ่งเป็นคนในเขตต้องเรียกว่าคนมองในยุโรปกับคนมองในอาเซียนย่อมไม่เหมือนกันนะคะในบางครั้งการโฆษณาสินค้าในประเทศอเมริกาอย่างเช่นเหล้าไม่มีกำหนดเวลาแต่ในประเทศที่เป็นศาสนาพุทธหรืออะไรอย่างเงี้ยนะคะก็อาจจะมีข้อจำกัดว่าเรายังมีวัฒนธรรมที่แตกต่างงั้นในจุดเนี้ยทั้งฝ่ายผู้คัดค้านน่าจะต้องนำเสนอนะคะว่าถึงความแตกต่างเพราะเราแพ้ในชั้นคำวินิจฉัยนะคะทีนี้มาชั้นศาลเราก็ต้องนำเสนอให้ได้เพราะในคำวินิจฉัยของอนุญาโตตุลาการให้ประโยชน์กับทางฝ่ายผู้ร้องและว่าให้ทางฝ่ายประเทศสารขันชำระค่าเสียหายซึ่งเป็นประโยชน์กับทางเราต้องเอาดุลพินิจของคำวินิจฉัยอันนั้นขึ้นมาต่อสู้โดยเพิ่มน้ำหนักให้มากขึ้นซึ่งก็เห็นมุมมองของฝ่ายผู้ร้องได้ทิ้งน้ำหนักไว้อย่างดีมากนะคะมาตรการแซงชั่นต่างๆทางภาษีไม่ควรนำมาใช้กับมาตรการที่มาจำกัดเสรีภาพในการโฆษณาซึ่งก็เป็นมุมมองที่สอดคล้องกับกฎหมายนะคะว่าเป็นทฤษฎีเกี่ยวกับการจำกัดการแข่งขันว่าในเรื่อง free trade area เป็นยังไงเราก็ต้องยกขึ้นมาซึ่งเราก็ได้ดำเนินการชี้ให้ศาลโน้มน้าวศาลว่ามีมาตรการอื่นๆอีกมากมายที่รัฐทำได้แต่ไม่ควรจะมาจำกัดเสรีภาพในการค้าในแง่ของการโฆษณาซึ่งพลาดไปนิดนึงว่าน่าจะนำเสนอการลงทุนโฆษณาลงทุนไปเท่าไหร่จริงๆโจทย์มีให้แล้วนะว่าประเทศของโจทย์เนี่ยมีการลงทุนโฆษณาด้วยเงินจำนวนมากทีนี้เครื่องหมายการค้าถามว่าเรามุ่งคุ้มครองอะไรคะเรามุ่งคุ้มครองตัวเทรดมาร์คหรือเราคุ้มครองธุรกิจในแท้ที่จริงใน TRIPS เองมีวัตถุประสงค์ในการทำความตกลงร่วมกันในบริบทแรกเลยในเรื่อง purpose วัตถุประสงค์หลักของการคุ้มครอง intellectual property คือทรัพย์สินทางปัญญาก็คือเรามุ่งคุ้มครองในกฎหมายนั้นนะคะในกฎหมาย TRIPS เองนะว่าเราคุ้มครองประเทศสมาชิกทุกคนเนี่ยคุ้มครองธุรกิจภายใต้เครื่องหมายนั้นเพราะฉะนั้นต้องมองไปที่ธุรกิจด้วยถ้าเราจะคุ้มครองแต่ trademark มันคงไม่ใช่เครื่องหมายอย่างเดียวเราต้องมองคุ้มครองธุรกิจเพราะฉะนั้นธุรกิจจึงเป็นสิ่งสำคัญที่เกี่ยวข้องกับการค้าในระหว่างประเทศมากมายซึ่งเราน่าจะยกขึ้นมาถ้าเรามองตรงนี้ออกปุ๊บมันจะเห็นสายต่อเชื่อมโยงได้ทีนี้ทางฝ่ายของผู้คัดค้านเองก็นำเสนอได้แยบข่ายนะคะมียกข้อตกลงเรื่อง TRIPS อะไรต่างๆขึ้นมาเยอะอยู่เหมือนกันซึ่งศาลก็เห็นมุมมองที่เข้าใจกฎหมายแต่ว่ายังไม่ได้เน้นน้ำหนักที่ว่าอะไรคือนโยบายของรัฐนะคะนโยบายของรัฐที่ชัดเจนเนี่ยมีแต่ขัดต่อความสงบ ไม่ได้พูดว่าสุขภาพและอนามัยของประชาชนส่วนใหญ่มันคือความสงบนะคะความสงบของในระดับชาติซึ่งต้องเรียกว่าเป็นเกี่ยวเนื่องด้วยความสงบในระดับสากลทีเดียวนะคะถ้าเรายกขึ้นมาเนี่ยมันจะมีน้ำหนักมากเลยทีนี้นี่แหละค่ะการต่อสู้ในการนำเสนอข้อเท็จจริงต้องนำเสนอให้โน้มน้าวจิตใจให้ผู้ศึกษาเนี่ยได้เห็นว่าคำพูดของแต่ละฝ่ายคนใดมีน้ำหนักมากกว่ากันแล้วนำเสนอข้อเท็จจริงอะไรให้เชื่อตามนะคะแต่การเชื่อตามนั้นต้องอยู่บนเบสของข้อกฎหมายด้วยที่รับฟังได้นะคะก็จะประกาศหรือว่าท่านอาจารย์มีคอมเมนต์อะไรไหมคะท่านประธาน
ผมว่าต้องประกาศเลยนะครับ
ค่ะ
ก็เป็นสิ่งที่หนักใจที่สุดนะครับในการที่ต้องเลือกนะครับแต่ว่าเมื่อเรามีหน้าที่ชี้ขาดเราก็ต้องชี้ขาดก็ต้องเน้นนะครับว่าการชี้ขาดเนี่ยเป็นการชี้ขาดโดยดูที่การแสดงออกในด้านความสามารถในการจูงใจความสามารถในการที่จะแถลงการปิดคดีไม่ใช่หมายความว่าคณะกรรมการเห็นด้วยหรือไม่เห็นด้วยกับมูลคดีที่เถียงนะครับเป็นเพียงเรื่องของความสามารถที่ต้องขอแสดงความยินดีกับคณะนิติศาสตร์ของทั้งสองมหาวิทยาลัยที่ได้ผลิตนักกฎหมายรุ่นใหม่ที่สามารถแสดงออกมาในลักษณะนี้ที่จะให้การว่าความในศาลมีคุณภาพสูงขึ้นเพื่อที่จะช่วยผู้พิพากษาในการที่จะเขียนคำพิพากษาได้ดีคนที่จะทำให้ผู้พิพากษาเขียนคำพิพากษาได้ดีก็คือทนายความที่ทนายความที่เชี่ยวชาญและมีความชำนาญพิเศษในเรื่องนั้นๆแล้วค้นมาแล้วศาลก็เป็นเพียงดูว่าข้ออ้างข้อเถียงของฝ่ายใดน่าเชื่อถือมากกว่าเพราะฉะนั้นมันเป็นศิลปะในการจูงใจซึ่งอาจจะเป็นผมคิดว่าเป็นการแข่งขันที่สูงสุดและได้ประโยชน์สูงสุดในวิชาการกฎหมายของโรงเรียนกฎหมายต่างๆในโลกนี้การแข่งขันของโรงเรียนกฎหมายต่างๆในโลกนี้คือการแข่งขันมูดคอร์ตนี่แหละเดี๋ยวนี้เขาอาจจะพัฒนาไปถึงการแข่งขันมูดคอร์ตที่ไม่ใช่มาเถียงปัญหาข้อกฎหมายแต่เป็นการทำเรื่อง mood conciliation คือการไกล่เกลี่ยเพราะฉะนั้นหน้าที่ของนักกฎหมายในการระงับข้อพิพาทก็คือการไกล่เกลี่ยหรือการต้องชี้ขาดก็ต้องชี้ขาดแต่ว่าสิ่งที่สำคัญที่สุดคือความสามารถในการจูงใจให้คนที่ต้องชี้ขาดคล้อยตามในสิ่งที่ถูกต้องและเป็นธรรมก็ชื่นชมคณะนิติศาสตร์ทุกแห่งที่ส่งเข้ามาแล้วก็โดยเฉพาะอย่างยิ่งกับคณะนิติศาสตร์ของทั้งสองทีมทั้งสองฝ่ายที่แสดงความสามารถได้ก้ำกึ่งกันมากครับ
ค่ะก็ต้องถึงเวลาที่ต้องประกาศด้วยความหนักใจเหมือนกันนะคะว่าทีมไหนจะเป็นทีมที่ได้ชนะเลิศนะคะก็อย่างที่ท่านอาจารย์บอกก็ไม่ให้เสียเวลาไม่งั้นก็ทุกนาน ก็ขอประกาศว่าทีมชนะเลิศก็ได้แก่ทีมของผู้ร้องค่ะคือ I Believe I Can Fly จากมหาวิทยาลัยนเรศวรส่วนทีมรองชนะเลิศก็คือทีมฝ่ายผู้คัดค้านคือ R&B Law จากมหาวิทยาลัยเกษตรศาสตร์ค่ะ
ขอบคุณทุกท่านนะครับเดี๋ยวภาษาอังกฤษจะตามมาครับ
ครับเราได้ผู้ชนะสำหรับทีมภาษาไทยนะครับขอแสดงความยินดีกับ I Believe I Can Fly นะครับแต่ท่านผู้มีเกียรติอย่าเพิ่งลุกไปไหนนะฮะ ความตื่นเต้นของเรายังไม่หมดเพียงเท่านี้นะครับท่านคณะกรรมการกำลังจะขึ้นมาประกาศผลการแข่งขันของทีมภาษาอังกฤษในไม่กี่อึดใจข้างหน้านี้นะครับขอย้ำอีกสักครั้งหนึ่งครับสำหรับรางวัลผู้ชนะเลิศในวันนี้นะครับที่จะได้รับไปนะครับน้องๆจะได้รับทุนการศึกษานะครับพร้อมด้วยการเดินทางไปศึกษาดูงานและทัศนศึกษายังต่างประเทศนะครับพร้อมด้วยการเข้ารับฝึกงานที่สำนักงานกฎหมายชั้นนำของประเทศไทยและเกียรติยศอันสูงสุดนะครับนั่นคือการเข้ารับถ้วยรางวัลประธานจากพระองค์เจ้าพัชรกิติยาภาด้วยครับและขณะนี้ท่านคณะกรรมการทีมภาษาอังกฤษน่าจะพร้อมแล้วสำหรับการประกาศผลทีมผู้ชนะเลิศนะครับขอเรียนเชิญท่านคณะกรรมการครับ
Ladies and gentlemen, finally, maybe we have to announce the result, which is the least important part of this exercise. The most important part is that the opportunity for our law students to come and practice the art of advocacy, which is maybe lacking before. So this is the opportunity for the law students in order to practice the law in action, and the law in action as at the highest level. That makes us and me in particularly very proud to see our young generations to be able to argue on the point of law of most importance, not particularly in domestic law, but in international law, public international law, in conflict of law, in intellectual property law, investment law, and arbitration. So this is a syllabus which maybe law schools in the world now share. You study law in this country or any other countries in the world, we share the same syllabus on these subject matter of the law. So today we witness some of the very competent young lawyers, not particularly these two, but those who have appeared before in both Thai and English, and particularly English. You do take special effort in learning a new language and to master it as if it were your own. They say that the people who write the most beautiful English are not the English, they're the Indian. They maybe they have the ability of the most important of all, the love to enjoy the literature. And if you love doing something, you excel it. Language is not an exclusive right to anybody. Language is universal. So Thai is a universal language. English is a universal language. So we do not have any hindrance to study English. We do not study English because our ancestors did, but we choose to study English because it helps us, it helps our society, and help yourselves in the future in order to serve our country. So congratulations to both teams and both law schools. And before today, we are kept in secret of the law school that they are from. But today, and just now, we can reveal that the council from this side, the council from the Clemens are from Ram Kamhang University. Is that correct? Yes, the great Ram Kamhang Law School, which is the law school which has produced many fine lawyers for Thailand. And this side is the oldest law school in Thailand, the Thammasat University Law School. But are you from the English program? Both of you? Yes, so this is an innovation from Thammasat University to have an English program. studying Thai law in English. So this is a bold step. Now we look at both sides, and we are looking forward for you to represent Thailand in international moods competition. You don't go there and teach the judges. Both of you try and come and explain the law. Well, there are 3 elements, 1, 2, 3, and 4. No, you just highlight the issue that is relevant and argue the point. And most importantly, it's not your opinion. You have to cite the authority. The authority might be from a court decision, might be from textbook of learned authors, authorities in that field, and cite those authorities, but not just to explain the law to the court. But both you are doing fine, but the result is unanimously given to the, I'll be very careful now, it reminds you of a certain beauty pageant, isn't it? And when they opened this and then they got it all wrong, so I'll be very careful. This is the decision to go to the oldest law school in Thailand. The respondent, Thammasat University. Is that correct? Yes. And we also give very high commendation to Ramkhamhaeng University. And on behalf of the Chief Justice, thank you for attending this moot competition, which is organized by the Central Intellectual Property and International Trade Court. It should have been organized by law schools, but then we did. So thank you for coming. See you whenever it is organized again. Thank you.
All right.
ครับและเสร็จสิ้นลงเป็นที่เรียบร้อยแล้วนะครับสำหรับการแข่งขันการแถลงการปิดคดีด้วยวาจารอบชิงชนะเลิศในโครงการทูตเยาวชนศาลทรัพย์สินทางปัญญาและการค้าระหว่างประเทศกลาง CIPIT Court Young Ambassador Award 2017 นะครับขอแสดงความยินดีกับทีมชนะเลิศทั้ง2ทีมนะครับสำหรับภาษาไทยได้แก่ทีม I Believe I Can Fly นะครับจากมหาวิทยาลัยนเรศวรและทีมภาษาอังกฤษนั่นคือทีมผู้มี่นะครับสำหรับมหาวิทยาลัยธรรมศาสตร์ศาลทรัพย์สินทางปัญญาและการค้าระหว่างประเทศกลางนะครับขอบพระคุณท่านผู้มีเกียรติทุกท่านที่ได้กรุณาสละเวลาเข้าร่วมเป็นสักขีพยานและร่วมเป็นกำลังใจให้กับน้องๆทั้ง4ทีมในวันนี้นะครับและที่สำคัญโครงการนี้ได้สำเร็จลุล่วงลงได้นะครับต้องขอบพระคุณหน่วยงานผู้ร่วมจัดโครงการรวมถึงหน่วยงานผู้สนับสนุนดังมีรายนามดังต่อไปนี้ครับขอบคุณกรมทรัพย์สินทางปัญญาองค์การส่งเสริมการค้าต่างประเทศของญี่ปุ่นหรือเจโทรกรุงเทพบริษัท True Corporation จำกัดมหาชนสำนักงานกฎหมายดำเนินสมเกียรติและบุญมาจำกัดบริษัท Baker and McKenzie จำกัดบริษัท Burley Yuger จำกัดมหาชนเครือเจริญโภคภัณฑ์บริษัทปูนซีเมนต์ไทยจำกัดมหาชนบริษัทโมโนบรอดคาสต์จำกัดสำนักงานเพื่อการพัฒนาระเบียงเศรษฐกิจพิเศษภาคตะวันออกบริษัท Triple Tree อินเทอร์เน็ตจำกัดบริษัท Big C Super Center จำกัดมหาชนบริษัท PTT Global Chemical จำกัดมหาชนและธนาคารไทยพาณิชย์จำกัดมหาชนครับขอบพระคุณท่านผู้มีเกียรติทุกท่านอีกครั้งหนึ่งรวมไปถึงท่านผู้ชมทางบ้านด้วยนะครับที่ติดตามรับชมการถ่ายทอดสดที่ศาลทรัพย์สินทางปัญญาและการค้าระหว่างประเทศกลางในวันนี้สำหรับวันนี้ช่วงเวลาการถ่ายทอดสดจบลงแล้วนะครับขอบคุณทุกท่านและสวัสดีครับ